Let's take this to the judge. Fox News senior judicial analyst, Judge Andrew Napolitano. Judge, it's good to see you.
Good to see you, Shep.
I remember producers and I were talking about how this sort of thing has happened repeatedly lately, thankfully. Remember the suspect in California, the cop who was going around killing cops? He hit
right.
He let a man live, and that man led to his demise. In this case, he let the carjacking victim live, and arguably that led to his demise as well.
Yeah, the statement that you just quoted, which is exceptionally chilling, comes from a 10-page affidavit signed by an FBI agent. The FBI agent relates in that affidavit that he has reviewed much of the evidence, not all of it, but much of the evidence, including all the videotapes, and he has summarized all of it in this affidavit. The purpose of the affidavit is to back up a criminal complaint. The criminal complaint must be filed within 48 hours of suspect number 2's arrest. This is not the complaint on which he will be tried, because the next document will be, or eventually there will be, an indictment from a grand jury. This is sufficient to keep him in jail until the grand jury can meet and decide what it will indict him for. That indictment, because this complaint is just a half a page long, Shep. The grand jury indictment will probably be very, very long and be filled with details and will charge him with more than just the 2 crimes for which this charges him.
We could have anticipated these questions over whether he should be held as an enemy combatant or whatever. They come up every time.
Yes, they do. Now, there's 2 aspects to enemy combatant. One is trying a person as an enemy combatant before a military tribunal in Guantanamo Bay. That is not legally possible in this case because he is an American citizen and was an American citizen at the time these events took place. The other enemy combatant designation is one that would put him in the custody of the military for 30 days, during which he could not communicate to anyone and during which the military and others in aid of the military could interrogate him relentlessly for 30 days. In order for that to happen, there would have to be unambiguous evidence of his being affiliated with a foreign group like Al-Qaeda that is waging war on us. According to the governor of Massachusetts, the mayor of Boston, their chief police people, and the head FBI agent in Boston, there is no such evidence. So that's probably why they're not going to go that route.
One more thing, the matter of reading him his Miranda rights. You have a right to remain silent. There's an exception put into place in 1984, and the intent of that exception was, what if somebody had placed some bomb, for instance, placed some bombs out there, they brought him into custody, but there are more bombs that are about to go off. You need to be able to compel them to speak right now while waiting to read them their Miranda rights. That's an ambiguous thing. How long that period of time is. Do you have a sense now that that period of time, whatever it is, has passed and that it's time for us to do with the Constitution?
Well, the theory behind this exception is that the public is at risk. And the public is so much at risk that the potential defendant's constitutional liberties must be negated. But that doesn't make sense with, again, what those same people that I just ticked off said. The governor, the mayor, the state police head, and the police commissioner in Boston, and the head of the FBI. They all said on Friday night, Boston's back to normal. The public is no longer at risk. So they can't have it both ways. They can't
they're trying to.
They can't claim that Boston is back to normal and the public is at risk on one hand and say, well, the public is not at risk and we have to interrogate this guy on the other. The purpose of the exception to the Miranda rule is to protect police officers and those around the defendant at the time he's arrested. Is that gun empty? Where's the other gun? Where's the other bomb? The type of excited utterance one would normally utter at the moment of an arrest. It is not to find a way around the Miranda ruling. The Miranda ruling requires all government agencies, from a traffic cop to the FBI, to tell you before they ask you a question that you don't have to answer it. The Obama administration has taken a radical approach to the Miranda rule by coming out of nowhere with this 48-hour rule. That doesn't exist in any statute, and no court has ever permitted it.
Going to regret it?
I think they will regret it, because once they start using it, there'll be no stop to it.
Judge, thank you.